Welcome to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall.
Welcome to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall, founder of Marshall Law. I'm your host, Sophia Morales, and today's episode is the modern Brady Bunch, planning for children from second marriages. Welcome, John. I'm so happy to have you back here today.
Glad to be here.
Can you explain some of the unique challenges that come in estate planning when you have families that include children from multiple marriages?
It's amazing. When I started 20 years ago, most of my older clients, it was first marriage. Today, I probably deal with more second marriages than first marriages. And my primary office is near the Villages here in Florida. And yeah, we have people that come in and it's second, third, fourth marriages, children from prior relationships. And that presents some unique family issues, distrust between new parent or, in-law basically, and existing relationships in the family. The Brady Bunch television show, which I grew up watching, and who didn't love the fake AstroTurf and footballs to the nose and, all the other things, Marsha. But they were young kids growing up together. And the modern Brady Bunch is, children who are 30, 40, 50 years old, seeing a parent get remarried. And this isn't like, hey, we're going to grow up together and sing Kumbaya.
Sometimes it can be downright aggressive. Yeah,
it can be. But the interesting thing is sometimes the struggle isn't in the initial stages of the marriage. Sometimes it comes when one of the parents is now ill or there's a death. The unifying person that was there has now stepped out because of incapacity or they've deceased. And so what you have is the surviving spouse now dealing maybe with children from the other spouse's, pre-existing relationships, having a contentious relationship. And we see disinheritance happen. We see infighting, a lot of different things that happen. And again, a lot of that can be resolved through good estate planning.
Yeah, absolutely. I know if there are already answers in place, it certainly helps the situation, having been in one of those late in life Brady Bunch families. So
it's kind of the trend.
It really is. So how can parents in a second marriage like that ensure their children from previous relationships are provided for without alienating the new spouse, the new stepchildren? A lot of times there's this feeling like, well, you're having another family and replacing me.
So, the first thing I tell couples is if you're thinking of getting married and you've got children from prior relationships, talk to an attorney before you get married. Understand how your rights change in a marriage situation. A lot of people will say, you know what, let's go get married. We'll deal with it after the fact. What they don't understand is the second you get married, we now have marital rights that are established under the law. We have homestead right issues. So now we have a mandate under the law that here's certain things that you must do in order to provide for the other spouse. And if you don't follow these rules, then your kids may not get an inheritance, or again, they may not get as much as you intended. Different things can happen. So talk to an attorney first, understand what those marital rights are. And then in that conversation, talk about, well, what can we do to head off these issues? How can we set out the parameters? I want to take care of my spouse, but I don't want to disinherit my kids. So we can talk about, do you want to commingle assets, own them jointly, or do you own them separately? Do we do a premarital agreement? Or if you're already married, do we do a postnuptial agreement? And I know that a lot of people say, well, no, I don't want to do a prenup or a postnup because, we're getting married because we love each other. We're not contemplating divorce. Well, I tell people a prenup or a postnup doesn't mean that you're planning for divorce. I mean, granted, that could be a component of it. But we can also plan for, here's how we're going to treat things after death.
Yeah.
And it's funny because in the Florida Probate Code, there's actually a whole section that talks about agreements pertaining to the distribution of assets when parties die. Yeah. But we have to make sure that it's incorporated into the right type of document. But there's also certain trusts that we can create, Q-tip trusts, slats. I mean, and I'm not going to go down that rabbit hole right now,
I
but
was going to say
but
that's a
again,
whole lot of alphabet soup.
oh, there's a whole slew of stuff there. Don't get me started. But the funny thing is, there are tools, but we can talk about the family dynamics. We can talk about those tools, and we can explore the best way to ensure that there is harmony. But I can tell you this: when you plan and when you lay out, here's what we're going to do, and you communicate that to the kids, you can shut down a lot of the problems before they start.
Yeah.
The problems really only kick in when there isn't a plan, and then everybody wants to have their input in on it. And now mom and dad are being torn in different directions. If they plan in advance and they set the tone, well, now they have a unified front, and the kids can kind of accept it or reject it, but we're done. We've set the standard, and now I think what we have is a very good baseline to operate the relationship off of, not only between the spouses, but with the kids.
Yeah, and I think it's good to have those kinds of issues settled, not just legally, but even in your mind, right? Because one of the things I know my father struggled with was, if I die before my second wife, I want her to be able to remain in the marital home, but I want that home to go to my kids, And so I think if you don't plan for that sort of thing, that's when you end up in disaster.
And the funny thing is, there'll be attorneys involved afterwards because, you brought up the issue of, I want my spouse to stay in the house. Well, it used to be under Florida's homestead laws, the spouse got the right to stay in the house. They got a life estate, but all of that changed. Now the spouse can take a half ownership interest in the house. So again, the law, and I always tell people, if they say, well, I don't have a will, I always tell them, you do have a will. It's called the Florida Probate Code. The state of Florida has written it for you. The difference is you have the choice to modify it. And there's very few things where they say you can't modify this. But by and large, you can set the rules. But if you don't, some legislator who's probably been dead for 30 years, well, they wrote the rules that you're going to live by, or your estate's going to live by, and your kids are going to be stuck with, and same with your spouse. So,
Yeah,
plan it.
usually better to have some input into that. So, speaking of input into that, what are some of the considerations when you're creating a will that addresses both biological children and stepchildren, for example?
Well, the one thing that a lot of people don't understand is stepchildren are not heirs per
Oh,
se. They
okay.
can become heirs if there is nobody who would inherit except for them. There's a list of heirs in the Florida Probate Code, and stepchildren are so far down that basically you would have to run out of second cousins before they would inherit.
Wow.
Um,
Okay.
so sometimes though people say, well, I don't want the stepkids to inherit. Okay, well, that's fine. But at the same time, sometimes they go, yeah, my stepkids, I'm very close. I've raised them. I've been married to their mom for 30 years. Well, you know what? We got a plan because you can always bring somebody in, but the law does not necessarily guarantee that they're going to be treated equal with your own kids. So if you want them treated equal, we have to draft a document that brings them in. Now, at the same time, if you say, I want to bring somebody in, but I want somebody else left out, it also doesn't hurt to say, I've made no provision for stepkids or for my own kids or something like that. So we can expressly put that out there, explicitly stated so that there's no confusion. It's amazing to me. I'll have people say, well, I want to disinherit this kid, so I want to give him $1. And I have no idea where that originated from. Um, but yeah, if you want to disinherit them, we give them nothing. And we say we are giving them nothing because that restricts their rights with regard to your estate. And so we want to make sure that we address that. And that's kind of the big misnomer. The other misnomer is, that, well, I had assets coming into the marriage. My wife had assets coming into the marriage. And therefore, those are our assets. They're separate property. And we don't have rights in each other. No, the second you get married, there are marital rights that attach to those assets. And, we want to make sure that the children understand that, yeah, this was the home that maybe your dad or mom owned. They raised you in. But if they don't plan, you guys can be as upset as you want, but the law's the law. Your
Yeah.
parent could have addressed this. So when we're talking about biological children or stepchildren, those are the things that need to be talked about. Do you want them in? Do you want them out? How do you want them to get assets? Again, it all comes back to planning.
So when you're talking about communication between the spouses, I think you mentioned it was good for the spouses to be in agreement before they start sharing plans out. When it comes to sharing an attorney and sorting out assets, should you share an attorney? How does this work?
It's not uncommon for a husband and wife or for any married couple to share an attorney. Now, I make it very well known. I can represent you jointly. Attorney-client privilege attaches, except not between the two of you. One of you can't tell me something and say, "Don't tell my spouse." And if that's the case, we need to get you to each of your own attorneys. And sometimes it's not a bad idea, especially if there's conflict over how things are being done. I mean, right now I'm negotiating a prenuptial agreement. I represent the husband or the guy. Another attorney represents the soon-to-be wife. And we're negotiating things back and forth, but that way we have everything spelled out. And my relationship with my client, I'm able to give him very candid advice. But if we're representing a mutual couple, that's totally fine. They waive the conflict. And if a conflict comes up at any time, I can tell them, I must withdraw. I need to get you to two separate attorneys, but I'll make sure to get them both to quality attorneys that will represent each of their interests. At the end of the day, even if there is a little bit of conflict, what I would like to tell them is, one, have the conversation at home. Two, keep the kids out of it. Talk between yourselves. When you start bringing kids in, now you get like a lot of these, voices in your ear. And you really have to sit back and say, what is it you want? Okay. And then let the attorney know. You two talk about it. And, my job as an attorney is I'm a disinterested third party. I don't have a dog in the fight. I'm not inheriting from either one of you. So when you say, well, here's what we're thinking about, how do we handle this? Well, I can say, well, here are your options. So sometimes some of the areas that people think there's a conflict, it may just be in a conflict in how do we address it? Right. So as long as they give me information and tell me, here's what we're thinking, or here's what we're struggling with, most of the time we can work that out. But they have to be candid with each other and they have to talk, but keep the distractions to a minimum. And I know that they trust their kids, and I'll have one who'll say, my son's this great banker and he's a great money manager. I really value his opinion. And it's like, yeah, but he's biased.
Yeah, you're his can't be parent. Objective. Yeah.
And look, if my parents came to me and had a issue, I'm going to have a bias, not one over the other. But if my parents were married and my dad was getting remarried, I'm going to be biased towards him. Same thing with my mom. So again, I'm just not the party that has a bias in the situation. And I want to step back and let's try to find that common ground and a solution that works for what the clients want.
Speaking of solutions that work, how can you use planning things like trusts, instruments like that to protect the interests of children from the first marriage, from the second marriage, and ensure that you get the fair distribution to a new spouse, for example? So everybody may not be happy, but at least has been addressed appropriately.
So, it's interesting. There are so many tools out there. And when somebody says to me, what kind of trust can I do? And the answer is kind of like, well, there's about 1,000 different type of trusts we can do. So we really need to know the circumstance. I had one here recently. A gentleman came to me and said, look, I've got a lot of money. My wife doesn't have a lot of money saved up. I want to make sure she's taken care of. But her kids, I don't want them really getting the benefit of what I've spent my life working for. I want my kids. But my wife comes first. And I said, great. So we ended up creating what's called a Q-tip trust, Qualified Terminal Interest Property Trust. And yes, that comes out of the tax code, and we love acronyms. What that trust says is, hey, money's going to be held in trust. The spouse is going to get the income. There's distributions of principal to pay for her health, education, maintenance, and support. She's going to be taken care of. But when she dies, those assets are going to pass now to his kids. Now, again, that may be the best solution for their situation, but it may not be the best solution for the next couple that comes in. But that's just one example where we can use a trust to do things like that, where we can take care of the spouse, we can take care of the kids. We don't necessarily have to put everything in one basket either. We can have some money in one trust, some money in a different trust. but we have to talk about it and we have to figure out what is most appropriate to the circumstance.
And what role do you as an attorney play in helping couples navigate these kind of sensitive conversations that occur as you're going through the estate planning process, and maybe more importantly afterwards when you're ready to reveal it to everybody involved? Ta-da!
Well, and I touched on this a little bit earlier, because I've got my handy notes right here that you can now see on screen. So those of you at home, I'm kind of just waving paper here. The issue is, I said it before, I'm a disinterested third party. So if people will be candid and tell me, here's what I'm thinking, here's what we want, here's the issue that we're facing, I can then pull out my litany of planning options and go, okay, let's talk about, does that, circumstance, is this tool going to be the best? Okay, maybe not. Does this tool work? But sometimes it's also, well, let's flip it. Why don't we think in different terms? Is there a different asset that maybe we can move this over here and this over here? My job is to take input and then basically problem solve. And it's funny because I love doing puzzles. And pretty much my whole job as an estate planning attorney is puzzle solving.
Yeah, you're in the right profession for sure.
Yeah. You give me the pieces of your life and I've got to figure out how to put together a picture that paints a happy, unified, plan going forward. And it's a challenge, but it's something that I relish. But there are a lot of things that we can do, but I don't have a bias. So when you say, here's my issue, all right, let's develop it. Let's walk it through. Let's figure out what tools to use, because there are plenty of tools out there.
Exactly. So we kind of brushed up on this last question earlier, but I think it's valuable to spell it out. If you are thinking about marrying late in life, a second marriage, this sort of thing, what are the key steps that you need to take when you're in the process of planning to get married and sort out all this estate stuff?
So one, you need to determine, do you both use the same attorney or do you go to separate attorneys and kind of try to negotiate it that way? Either way is fine. I like working with both husband and wife because you're getting input from both parties. So sometimes when you're getting input from both parties, it's easier to bridge that gap than one attorney having one set of facts, another attorney having another set of facts, and then trying to negotiate a middle ground. But, you have to basically lay it all out. Don't hold anything back. Here's the facts. Here's the circumstances. Here are the issues. Let's talk about your kids. How are they responding to this relationship? What can we do to help, minimize family disharmony? But you've got to give me information. So I will bring a not disinterested, but an unbiased approach to it because I'm very interested. I want to solve it, but I don't bring a bias to it. But you've got to give me good information so that we can develop a plan that properly addresses it. But I got to tell you too, people who are in relationships and not married and saying, hey, you know what, for whatever reason, we're not getting married, you still need to talk about this estate planning issue. I had somebody that he wanted everything to go to his girlfriend. He died. She is not an heir.
Yeah, that is not the way the state's going to handle that.
No. And she didn't even come up on a possible list of heirs. So again, this is where I tell people, whether you're in a committed marriage, thinking about marriage, or you're just going to live together long term, these are conversations you have to have so that you don't get hit with, the uncertainties. Murphy's Law is out there ready to be applied. I prefer to avoid Murphy's Law.
That's wonderful. I really appreciate that wrap up there, John. That's perfect. And thanks for joining me here today and sharing all this amazing information with us.
Thank you.
Thanks for tuning in to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trust with Attorney John Marshall. To connect with the team, head to marshallawpa.com and be sure to like, subscribe, and review.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.